Hello, Christopher. Thank you so much for joining us today. For those who are watching, I would love to ask you to just introduce yourself to everybody and what you do.
Well, thank you very much for having me on, Beth, and it's lovely to talk with you and your viewers. My name's Christopher Robertson, and I am an intellectual property specialist. I work in my own firm, Robertson IP, which has the mission, if you will, to make intellectual property more accessible to small businesses, entrepreneurs, even private individuals who otherwise would not be able to protect their ideas, protect their reputation using the traditional routes. I've been going since 2019 and I've been working in IP since 2012.
Amazing. And Christopher and I have already had a meeting where he blew my mind about a few of the little caveats towards IP and copyright. Now, that's going to be the main subject for today. We're going to pick Christopher's brains on his expertise, but just a little disclosure, just a little preface for anyone watching. Christopher is based in the UK, and although we're going to do our best to keep the advice kind of general, just for you to know there might be certain things you need to look up in your exact area because, yeah, the watchers of this show range from everywhere from the US to Australia. So there's a lot of scope in between there that I'm sure there's some differences in what some of the laws look like.
Absolutely. I'll try to keep that in mind and mention where things are jurisdiction specific and which principles apply more broadly.
Amazing. So talking then about IP, we've kind of jumped into a term there that people might not be familiar with already. So what is IP and why is it relevant to the people watching?
Well, IP stands for intellectual property, and intellectual property is an umbrella term for a number of different concepts and rights in law. And they can be typically categorized into two categories. The first category deals with the products or fruits of one's creativity, and the other protects one's reputation and the goodwill invested in your business, your goods, your services, that sort of thing. So if we talk about the creativity side of intellectual property, this is where most of the different rights that you will be familiar with fall. So the first one, the one that I deal with the most actually, is patents. And patents protect inventions. They're technical in nature, and a patent grants an inventor or their successor the right to exploit an invention without competition for a period of time, or at least to control the competition in the exploitation of their invention. Then there's registered designs, and these are aesthetic in character rather than technical. So it is possible to protect if you design furniture or products or whatever it might be, or even patterns for wallpapers or backdrops or anything like that, these can be protected with design registration. Now, design registration is one of those things that does vary a little bit more from country to country. In Europe, they're called community designs. In the UK, they're called registered designs. In the US, they're called design patents. In many other countries, they're called industrial designs. And there are different levels of strictness, I would say, from country to country when it comes to the aesthetic nature of them. So some countries will simply not grant you a design unless there is an aesthetic quality, whereas others will not really examine that very carefully and will just grant it for the look of any product, whether there's any design gone into it or not. The UK is quite strict, so there has to be an element of design, of aesthetic quality to your product if you are going to register it as a design. Then we have trade secrets. These are not a right or an asset that can be registered in the same way as the other rights that we'll be talking about. Rather, this is a regime instituted by law, by statute, which means that you can be protected from the consequences of industrial espionage or your industrial secrets getting out, provided you have taken appropriate steps to try and prevent that from happening. And the final one is copyright. Copyright is probably the one that affects most of us because everybody has created copyright content. This isn't something which is registered, at least not in the UK. Some countries do have copyright registries, but typically it is automatic. As soon as you record the literary, artistic, or dramatic work in question in any format, then it is protected by copyright. And then moving over to reputation. And this is where we talk about trademarks and goodwill. Trademark, and particularly a registered trademark, is a right, an asset, something which is registered and granted by the local, the local patent office or trademark registry, and it enables you to prevent competitors using branding which is similar to yours in such a way that it might confuse your competitors, confuse rather your customers. And goodwill is simply that sort of attractive force which draws customers to your products rather than those of your competitors because of your good reputation, because they know that you provide a good quality service or a good quality product. And that's not a registered right. So there are ways you can stop other people passing off their goods and services as yours, even if you haven't registered your trademarks. It's more difficult, it's more expensive, so it is always a good idea to register the trademark.
And that takes us on beautifully to the kind of next focus there of, for the people watching who are service-based businesses, typically solo entrepreneurs, so it's very small scale business. Why should they consider trademarking their business?
Well, there's a lot of good reasons to register a trademark for your business. So let's just first of all be clear what a trademark might be. A trademark is any sign that you use to tell your customers that the services or the goods that you are selling come from you and not from one of your competitors. So a trademark isn't about describing or telling your customers what you're selling. It's about telling them who is selling it. So one of the most famous trademarks in the world is the big golden M of McDonald's. Now, if you look at that, you actually derive no information at all about burgers or fries or anything like that. But you know that if you buy burgers and fries under this sign, it's coming from McDonald's. It's not coming from Burger King or anybody else. So that is the purpose of a trademark. And they can come in all sorts of forms. Obviously, your business name is a trademark. Your logo is a trademark. If you have a tagline that you use in your marketing, that can be a trademark. If you have a jingle that you use in your audio adverts, that's a trademark. If you have a particular color scheme, like the famous blue and yellow of IKEA, that can be a trademark. Cadbury's purple on their chocolate wrappers, there's a trademark right there. So trademarks can be all sorts of different kinds of things. In the United States, it is possible, not necessarily very easy, but it is possible to even register a smell as a trademark. If your products or even your shop environments have a trademark smell to them, then you can register that. In Europe, it is not possible.
Yeah.
The reason in Europe you can't register a smell is because the law requires that in order to register a trademark, even if it's not a typical sort of image trademark or word trademark, it has to be something that can be accurately represented on paper, as it were. So obviously you can do that with an image or with a word just by writing it or depicting it. You can do it with a color scheme just by using Pantones or printed representations of those colors. You can do it with a jingle just by, for example, using the sheet music. But it's very difficult to say whether one can accurately represent a smell in writing. And if anybody ever manages to do that, then you'll be able to do it in Europe, I'm sure.
So scratch and sniff doesn't quite count there.
No, unfortunately not. So I like your thinking, but no, but not least because most paperwork is submitted to patent offices electronically now. Why should you register it? Well, the first reason, I suppose, is because it shows your customers and it shows your competitors that you are taking your own brand seriously, that you recognize its value, you recognize it as an asset. And that is a great message to be sending to your customers and to your competitors. The second reason is that you can actually use the trademark registration to enforce it. You can stop third parties using similar branding to sell similar products in the same place that you're selling them. And in that way, you can stop your customers getting confused. Am I buying this from this person or is it from somebody else who just looks like them? It can protect your reputation, because if one of your customers in confusion buys a product from your competitor, because it's branded in a similar way to yours, that product is inferior, then they're suddenly going to think, oh, not buying from Beth then again. That's rubbish. It's damaging your
Yeah.
reputation. And so registering the trademark gives you the power to stop them selling their products or their services under confusingly similar sign. And that's the main reason, I suppose, historically why trademarks have been registered. The third reason is that it's an asset. Suddenly you have this additional piece of property in your business's name, and it has a value. It can be sold, mortgaged, insured. You can use it to franchise your business. You can use it to attract investment. It is something which, if you nurture your brand, can grow in value. So, it costs a few £100s to register a trademark, and the most valuable trademarks in the world are worth tens, if not hundreds of billions of pounds. Coca-Cola having the most valuable trademark by most people's reckoning at the moment. So it is an investment in a way, your reputation and your brand, and it's something that can grow in value and pay off down the line. And the fourth reason is, if you don't, then you can lose it. If you have your trademark and you use it and then don't register it, and sometime later one of your competitors does register it, then they can stop you from using it. And the fact that you were using it first is not in itself a defense against trademark infringement. And so you would have to stop, you'd have to rebrand, rename your company maybe, print all your stationery again, buy a new domain name. I mean, it would be a nightmare of untold proportions. There are defenses that you might have access to in those circumstances, but they are fairly narrow in scope and probably don't apply to most of your viewers, most of your listeners. And so it really isn't worth the risk for the sake of a few £100s. That would be my advice.
Yeah, and I suppose for the people who are watching, like, we're talking to very small business owners, we're talking to micro businesses that might not necessarily have the power to be able to go up against a bigger organization if the issue came to be, which makes the importance of it so much stronger. Because if you're just you in your business and trying to build a brand, protecting it makes so much sense, because somebody could come create a business with 100 employees and a budget 10 times yours and be able to kind of stomp on that and protect it with the money that they've got for endless IP lawyers and resources that you might not necessarily have.
Absolutely. It really is much easier to defend your own position if you have the trademark registered in the first place than if you don't.
Yeah, and it comes to mind, like, so my background came from social media and marketing. That's my kind of space and where I started in business. And I could name you at least 3 marketing agencies that are all called the Social Butterfly Marketing. And I know that they're different, and I know that they exist in different spaces and all of that sort of stuff, but it is confusing for a consumer. And if you were to Google and a result came up, all of their logos and branding include a butterfly. All of their positioning have quips and jokes about nature, which is a great brand and standalone would be wonderful, but that confusion of who you're finding must be a nightmare for being able to kind of stand strong in what they do.
Absolutely. So their brand recognition is immediately diluted to 1/3 strength, isn't it? And, the value of it, whereas intrinsically it might be quite high because of those other people in the same space, it's just slashed.
Yeah.
Whereas if the first of them had registered it as a trademark and used that trademark appropriately, perhaps the others would have gone off and found their own unique brands, and they'd all have been in a stronger position.
Yeah. And I'm sure it's coincidental in this case. I don't think these people know of each other in any way, but it's just one of those names, those phrases that came to mind. But yeah, it's something to consider. Now,
it is, and it's also important, to point out that if you are coming up with a brand at the beginning of your journey, whether or not you intend to register a trademark straight away, you should, but whether or not you're intending to, you should at least have a clearance search made of the trademark registry, just to make sure that you are not inadvertently infringing somebody else's trademark, to make sure that there isn't somebody out there who's already registered it as a trademark. And this should be accompanied by the kinds of searching, just Google searching, domain name searching, to make sure that the domain names are free, that there isn't somebody out there who is using similar branding but hasn't registered it yet themselves or whatever, just to make sure that you are starting from a strong position brand wise and making sure that you're not in someone else's territory, or you're not in danger of somebody else encroaching on your territory.
Now, I'm sure that might be a little bit overwhelming for the people watching. They're like trying to come up with something that no one's ever thought of before. Just from my understanding, it's sort of different categories within IP. Is that correct?
Trademarks are registered in different categories. Yes, absolutely. They're called classes. There's 45 classes relating to different goods and services that you might be selling under your trademark. Typically, trademarks can be registered in more than one class if you are selling multiple different kinds of things or multiple different kinds of services. But one of the things that's taken into account when assessing the similarity of two trademarks is whether the goods and services being sold under them or for which they are registered are similar. And so you can absolutely register Apple for the sale of computers. You can't for the sale of apples, because you can't register a descriptive trademark. But even though somebody's already beaten you to it with computers, they might not be selling, I don't know, staplers under Apple. So it may still be possible to register the trademark Apple for staplers. That was probably not the best example to use, actually, because there is a provision, no doubt brought about by the immense lobbying power of the very, very large corporations, which mean that a very, very well-known trademark has rights even in other categories that aren't related to the ones it's registered in. So a normal trademark, you can only enforce it against the sale of similar goods and services, but the most well-known ones, and I'm very sure that Apple would be among them, they can potentially enforce even beyond that scope for anything.
Yeah, and I think that's an important caveat just to point out, because I know, for example, there is a Bethan Wright who is an actress. She was a Disney Channel actress and now has like a YouTube channel, and that's her brand, and I'm sure it's probably trademarked at some point. Whereas if I were to trademark Bethan Wright as a coaching business, would be a completely different category. It wouldn't necessarily be any overlap. So if you were listening and thinking like, oh my God, like I'm sure there's other businesses that must exist with my business name, it's not just about making sure it's something that's never existed before. It's about that kind of brand recognition and where it sits within the trademarking laws.
Absolutely. Now, one surefire or nearly surefire way of coming up with something unique when we're talking about naming brands, word brands, is just to make a word up, because you're much less likely then to have something that somebody else has already come up with. But
However,
even if you go on.
I was going to say, from a marketing background, an SEO background, that's a terrible idea for getting your things found online.
That's a shame. Right. Okay. So, well, I suppose you've got to find some happy middle ground in that case.
Yeah.
But if you find that if you're really invested in a particular brand name that you want to register as a trademark, and you find that it exists out there, and you're not sure whether it's very similar goods and services, you're not sure where you stand, well, you could apply anyway and see whether the other party objects. And if it becomes problematic, you can always try and negotiate a coexistence agreement. There are plenty of trademarks out there. There are plenty of businesses out there who are operating under quite similar trademarks, but they've agreed the terms of coexistence. I won't try and expand mine that way. I won't ever turn my logo green so that it's like yours, or whatever it might be. So there, all is not necessarily lost, and it is always worth talking to a professional just to see what your options might be.
Amazing. And I do want to touch upon, we're talking a lot about trademark. I think one of the other key pieces for the small business owners watching this will be this idea around copyright. Could you explain a little bit more? I know the process of using copyright is very different. How does that work?
Absolutely. Now, copyright is a protection for literary, artistic, and dramatic works. So if you write a novel, that's protected by copyright. If you take a photograph, that's protected by copyright. If you paint a picture or perform a dance, then In the case of the performance arts, there's got to be a record made of it. So if you perform a dance and somebody's filming it, that's protected by copyright. So it's always about the expression of an idea, either in writing or in music or whatever it might be, and some record made of it. So if you're giving a lecture, then if somebody takes notes, it's protected by copyright, but otherwise not. And the copyright owner is by default the creator, the author, if you will. So if you're giving a lecture and I take notes, then the copyright in my notes belongs to you because you were the one giving the lecture. Now, it may be that there's some share because I might be adding my own thoughts as I go through. Copyright can be complicated, especially when there's multiple authors. But basically, any creative work which is in some way recorded, is protected by copyright. In most countries, well, in all countries that have signed the Berne Convention, which is the sort of international harmonization of copyright convention, the protection lasts for at least 50 years after the death of the author. In the UK, it's actually 70 years after the death of the author, and in many other places as well. So it's a very long-standing right, and it means that the owner of the copyright has, in much the same way as other IP rights, they have the power to control the exploitation of that work. So if you have written a novel, then nobody else can then just copy a novel on their photocopier and sell their own copies of it, because that would be breaching your copyright. Like most IP rights, there is an exhaustion associated with copyright. So there's nothing stopping you from buying a book and then reading it and then selling it secondhand or giving it away to a charity shop. The copyright holder can't stop you doing that because you've already paid your dues to them for that physical copy of it. Obviously, with digital records, it's a little bit different because they're infinitely reproducible. So you might be able to keep it and send it on. So that's why there's laws preventing that kind of redistribution after you've bought something. But copyright theft or copyright infringement is rife now because of the internet. But part of it is because most people don't really understand copyright, and they don't understand what they can do and what they can't do. And so when you are creating content online, there are two things you need to think about. How do I take steps to stop other people copying it? And how do I make sure I'm not inadvertently infringing somebody else's copyright when I publish this content? Now, unlike the other rights, it's not an absolute protection. So, for example, you can infringe a trademark by accident, just by coincidentally selling something under a similar brand, and you didn't realize that was the case. Copyright is different. You actually have to have copied to breach copyright. So if you've written your 85,000 word novel, and then somebody else goes out and by extraordinary coincidence writes an identical 85,000 word novel, word for word the same, then they haven't breached your copyright, but they are going to have trouble convincing a judge that it is just a coincidence if they've written 85,000 identical words. But in any event, getting back to the question, so we talk about how to take practical steps to stop other people stealing your copyright work. If you're creating courses online or video content or whatever it might be, then obviously the legal side of it is covered because copyright is automatic. As soon as something is recorded, it is protected. But because there's a lot of ignorance, a lot of confusion about copyright, it is good practice to mark it, to mark your work as being protected by copyright. A typical way of doing this would be at the bottom of a page, bottom of the front page, for example, somewhere reasonably prominent, but not interfering with the aesthetic. Right, copyright, or the little C symbol in a circle, the year that you created the work, the name of the owner of the work, so either you, the author, or your business, all rights reserved. And that way, somebody looking at that will know this is protected. I can't use this. And they'd also then have a harder time convincing a judge, should it come to court, that it was inadvertent. There are other practical technological steps that you can use. If you're doing video content, then use a streaming system rather than downloadable files, whatever it might be. If you're selling images and you've got your portfolio online, then watermarking, all of that sort of thing. I'm sure the more computer savvy among you will know of other ways that you can make it difficult to just right click and save as an image. I'm sure there's code that you can use to do that too. And so it's worth either doing that yourself or getting somebody who knows more about these things to come along, have a look at your website, whatever, and implement those steps from a practical point of view. It's also good practice should you ever need to prove authorship of something. If somebody else contests it and says, well, actually, no, they copied me. I didn't copy them. Keep your drafts and date them. So if you're creating a new piece of work, then just keep all of your time-stamped versions all the way from the very first scrawls on a piece of paper to the finished product. If you use systems like Google Documents or so on, that's done for you anyway. It automatically records changes and timestamps them. So that's a good idea.
That was wonderful
Now,
news for me because I've never kept a draft
yes.
in my life. I hate extra files, and it blew my mind that the change history on Google was going to suffice. So yeah, it's good news for those of you out there who are Google fiends.
Yes, it is a good system. Now, avoiding infringing other people's work. Basically, if somebody else took the picture or created the image or wrote the text, your default position should be, I'm not going to use it. Just use your own content. Now, there are exceptions to this. So, for example, somebody writes you a testimonial. You can put that on your website. I would always get explicit permission for that, but I think there's
include
at least
it in your
implied
contract.
permission. Yeah, for creative people, designers and the like, your contract should have some sort of clause in it which gives you permission to use examples of work that you've created for somebody else in your portfolio, even if you are, and you probably are, assigning the copyright over to them once you've completed your contract. And there are all sorts of services that offer stock images and that sort of thing for people to use on their website. Make sure that you are using a reputable one and the appropriate licenses are included in the fee that you're paying. So make sure that it is licensed for commercial use when you are downloading that image and using that image. It's always nice to be able to use a quotation and so on. That's probably okay. There's plenty of people who've been dead for more than 70 years who said good things. So if you want to be absolutely safe, use those because their copyright will have expired. That's just something to bear in mind. If you're using something that was written by somebody else or a picture that was taken by somebody else, you've got to make sure you've got the permission, either because you've got the commercial license from your stock image or because you have explicit permission from the author. I also find Wikipedia is quite a good source of images because they're very good at explaining the license terms for the use of those images. If you click on an image in Wikipedia, it'll tell you who owns the copyright and whether they have given you permission to use it. And many of those images, you can use them for any purpose whatsoever, with or without crediting the owner of the copyright, depending on the particular terms. So it's a good place to, when you're starting out and you don't have much budget, might be a good place to start.
Yeah, and I know Canva is an interesting one because the licensing does allow for commercial use. You can put things on your website, you can put things on social media in both their free and paid packages. They include graphics and images and videos that you can use. But I've heard, and a really interesting kind of quandary with this, that it doesn't allow in their terms and conditions for you to take certain design elements and resell. So I know a lot of people will use a Canva template, kind of use that as a starting point, completely redesign it, and then maybe save that, sell it as a template online, whether that's a kind of a useful guide template, so it's like a checklist or things you need to know about a specific topic, or an actual design template. And that's against their terms and conditions. You cannot kind of resell these templates that already exist there. And I see these sorts of things happening a lot where it's completely unintentional. It's something that is just slipped the mind. It didn't realize that this was going to be an issue. And I wanted to touch upon that more with you because I even discovered in our last conversation that I have unintentionally broken copyright by showing screenshots during presentations in the past. And there's so much more kind of covered by copyright than I was even aware of. And I was aware of certain parts, especially the kind of written elements.
Yes, absolutely. So I suppose that is a specific instance of the general principle. If you're using anything that you haven't created yourself, that somebody else has created. Even if you're going to be modifying it, adding to it and so on, you've got to make sure you have the necessary permission to use it. You always need permission. And that permission, usually on these commercial services, comes from the licensee. You know, the mind-numbingly boring documents. They're long and you don't have time, but you really do need to read them, or you need to pay somebody else to read it and tell you what it says that's relevant to you, you know, a professional, a lawyer, or whatever it might be. Just because as soon as you start making money from something that you're not really entitled to make money from, you open yourself up to being sued, and it can be problematic. And it's so rarely deliberate, you know.
Yeah.
There are so many ways in which you can shoot yourself in the foot. So as long as you just keep in your mind that nagging thought, if I am using something that I didn't create, I need to make sure I've got the permission.
Yeah.
And hopefully you won't go too far wrong.
And I wanted to touch upon this idea of kind of fair use and educational use and that sort of thing, because I know a lot of people in the kind of coaching, mentorship, training spaces will lean on that fair use as an ability to be able to show examples of other people's work and kind of embed that into their paid for programs. How does that work?
It's a little bit risky doing that, I would say. So there are exceptions to copyright, and they do include education, but it's not paid for coaching that these things are directed to. It's more formal education, school. It means that a teacher can't be sued for photocopying a few pages of a textbook to distribute to the class. And that's where the fair use comes in. You know, it's not licensed to just reprint an entire textbook. It is a reasonable use in the context of that educational system. And so I would say that if you are selling a course, don't rely on those exceptions, and make sure that if you're using content, you have the necessary permission.
Yeah, I see that a lot, which is why I wanted to touch upon it. Is like, for example, someone doing a sales session and they'll show content from people's social media and be like, here's a good example and a bad example, sometimes anonymized, sometimes not. And yeah, you're essentially lifting someone else's work and reusing it without their say so. So one thing that we did talk about was the kind of context in which, and you were saying that if you show the piece in its natural format. So for example, if you opened up someone's website to show an example and you stayed on their website, that would be a different scenario than you kind of cutting and pasting to a presentation.
That is a different scenario, yes. So this is more relevant, I suppose, if you have a news website, and there are websites that collate content from different websites in order to sort of provide almost a catalogue or a menu of different pieces of information. And if they are copying and pasting content or text onto their own website, that is a breach of copyright. If they are simply providing a link and you click the link and it goes to the original website, that's fine, because you're not actually copying it, you're just directing the person to the original piece of content. Now, if you are giving a presentation and you are clicking on a link and showing a website, that might be okay. I mean, it's worth checking the terms and conditions of the website, you know, because there might be something in that, but you certainly can't just copy what's on the website and put it onto your presentation. That's a definite no-no. Yes, so check terms and conditions on the website, because they may expect you to use their website in a particular way. But linking from your own website to another person's website would not typically be considered a breach of copyright.
And I think where a lot of this confusion comes in is this idea that stuff is public. You can go and find all of this stuff everywhere for free. It's not behind paywalls. I think a lot of people, it just doesn't enter their brain that if you can't find it, why would it be something you couldn't use?
Absolutely. And that's a fairly new thing because of the internet, where everything is just so easy to access and everybody is a publisher if they want to be.
Okay. I always like to get practical in these sessions. Other than, of course, reaching out to yourself, how can people prepare and start the process of understanding what they should be doing to set themselves up effectively when this comes to IP?
Well, apart from consulting with a local professional in your home country. I know for a fact that the UK Patent Office and the European Patent Office and the European Intellectual Property Office have all manner of resources which are freely available to the public and which explain the basics of each intellectual property right that they administer. The United States Patent and Trademark Office, I know, has some great videos which might be a little bit corny to viewers in other parts of the world, but they're very well produced and they do explain things very well. So I would have a look on the website of your local patent office and see what resources are available. I know that in the UK, the British Library has a scheme to help people with their intellectual property, and there are various free workshops at libraries around the country which people from the patent office and even patent attorneys turn up and give out little bits of free advice and so on and so forth. And there may be similar schemes in other countries as well. So there's always plenty of information available. A general Google search in answering these questions, but actually in this day of blogging for the purposes of increasing your website's rankings on the internet, a lot of professional intellectual property attorney firms have some really good articles on their websites. And as long as you just check the date at the top and make sure that it's not years ago, because of course the law can change, that might be a good place to start as well.
Yeah. And I think from my side, kind of getting organized is going to be an interesting place to start as well. Like having a document of a list of things that you think could be trademarked or could need to be marked for copyright, and just really dive in deep into how much have you already got that you've not considered as a business owner. Like I know we have all of our own like social media content calendar templates and strategy documentation templates that I share with our clients regularly, and those don't, or currently, they will be shortly, I'm sure, but they're not currently copyright marked because it was just something really innocuous that didn't consider to me that it was, oh, made a template, there we go, sent on its way. And I'm sure a lot of the people listening, just by the nature of running a service-based business, have created so many resources that are going to kind of fit that bill, but haven't considered it until they go and do a deep dive in their files.
Absolutely. And if it's an overwhelming task and you've got a little bit of spare money, then wouldn't that be nice? But you can hire a professional like myself to do a comprehensive IP audit of your business and really lay out everything that you've got and actions that you need to take and quick wins that you can make by just doing a few things.
Okay, so the very last thing I always like to share is how can people find you if they are based in the UK and kind of needing this level of support? How can they reach out?
Well, they're very welcome to get in touch with me through my website, which is Patent Help, all one word, patenthelp.co.uk. They can find me on LinkedIn as well. And it's worth mentioning that I can help people all around the world. I have clients in many countries all around the world and a network of IP professionals in all different countries. So even if you were an American wanting an American patent and you don't know where to start, I'm very happy to put you in touch with the right people.
Well, hugely appreciate that. And I'm sure the watchers who have got themselves into a sticky situation and realize now they need to trademark immediately are feeling very similar. I'll pop all those links that Chris mentioned there in the description bar below so that they're easy to click through and find. And just as a final note, thank you so much for spending the time to share this expertise, because as you said, the Google search might not always prove to be the most valuable source of information on this topic.
Absolutely. It's my pleasure. Thank you very much, Bethan, for having me. And I've enjoyed myself very much.
Thank you.